Tony Louise comments, who may the general public, judge and jury? Stick to your own lives instead of sticking noses into everyone else's. So, should the public have the right to voice their opinions regardless of what they are on the internet? The media lawyer Jonathan Coad and the freedom of speech campaigner Robert Sharp joins us now from central London. Gentlemen, very good evening to you both. Jonathan Coad, if I could start with you, what's your view?
Well, we're in a societal issue here. These are the kind of opinions which used to be shared over a pint or over a cup of tea in a living room, and no one really thought anything about them. What's happened is they've now made a journey onto the internet via the social media, and at this point they have become much more powerful, and therefore the authorities have to make some kind of decision. And as Sally Bercow made a sort of parlour-style remark and put it on her phone and faced the consequences, now we've got to decide whether the general public must be put in the same position.
You wanted to come in there, Robert Sharp. What's your view?
Well, you asked about should the public have the right to their opinions. That's the way you frame the question. And absolutely, when they're just voicing opinions, I think they should have an absolute right, even when those opinions are unpleasant, even if they're now publishing those opinions where before they would have said them over a pint in a pub. So being offensive.
I mean, where's the line, do you think? Where do we draw the line, Robert Sharp?
Well, death threats is a good place to draw the line. I think the Crown Prosecution Service guidelines, which make a distinction between credible threats and things that are merely or just offensive, is a good one. And that's where the line should be drawn. I mean, it's an incredibly difficult and grey area, what constitutes a credible threat and what is just an opinion. But the kind of tweets that were incredibly insensitive that you showed on the screen just now were nevertheless opinions that the public has a right to express. And a lot of the tweets that we've seen in the dossier that you revealed today are just opinions. Or they're threats or unpleasant things that really aren't credible at all. And we shouldn't be criminalising that kind of free speech.
Jonathan Coad, you mentioned there the issue of perhaps a new law. We heard there from Robert Sharp talking about the difference between a credible threat or things that are just offensive and upsetting. We've got the Malicious Communications Act of 2003. It was drawn up to include emails but not social media. Do we now need a new law, do you think?
Well, there's no logic in separating emails from the social media. They're both forms of electronic communication, and as a matter of common sense, both must be covered by the law as to their content. The problem is that there is a law which prevents this, and again it comes down to a question of fact and degree, as Robert says. The Protection from Harassment Act puts people in a position where they can express an ugly opinion once, and that's lawful, but if they continue to express it and cause distress to an individual, that then does become unlawful, and it's something you can deal with in the civil courts, or you can take criminal action about. And here a judgment has to be taken as to whether the balance between Article 10 free speech and the rights for people to have an ordinary and reasonably secure life is taken in the right place. And the difficulty is that what may be considered to be friendly banter to one person may be deeply offensive to another. So we can take, for example, the call in to the unfortunate nurse by an Australian radio station is meant to be fun banter, caused enormous distress, and cause someone to take their own life. So this is an area where the law really struggles because there are so many subjective issues that arise.
Robert Sharp?
Yeah, there is a difference between social media and emails. If I email your actual address, I know that you're going to get that email. I know and I want you to see it. That's very different from tweeting Jonathan Coad or Adam Bolton's name into the ether. And that's the difference. That's the thing that social media is different from email or indeed writing a letter to someone's house. The one-to-one communications are targeted, are very personal in a way that social media, Facebook or Twitter, are really more like broadcasts, they're really more like publications. one thing that's quite interesting is the general public, by and large, don't realise that when they're tweeting or putting something on Facebook, they're publishing in the same way as the Times or the Guardian publish something, and they might get sued for libel or breach of privacy or something like
But
that.
do you really think that's the case? We've seen so many high-profile cases now over the past year or so of people tweeting offensive things, and several people have been jailed for what they said. Do you really think that's any kind of defence that, oh, well, I didn't really know that I was perhaps libeling somebody, slandering somebody because I didn't know it was being published? Well, anybody can see it.
I think most of the public don't really understand the nuances of the libel laws. I've been studying them for 5 years, and I still can't predict a case. So, I mean, when you're just speaking about someone, you're not even using their little Twitter signature in your tweet. There's no expectation, especially when you haven't got many followers like me, that person's going to see it. In which case, I don't think it amounts to a threat. The police, I think, are getting better at judging between what is a credible threat. They've been doing it with offline communication for years. The danger here is the chill. The danger is that we're getting a sort of privatised censorship where people know that these laws exist, and they might club together in a group to get someone prosecuted. That kind of privatised censorship that we're seeing is quite difficult and problematic.
Robert Sharp, unfortunately we are out of time. Thank you both. Jonathan Coad, also thanks for your time. Thank you.